My name is Mono Bisime. I'm from Counseling and Career Development, and I'd like to welcome you to our 2025 Law Professionals Workshop, Day 1. Now, what's going to happen is we'll be hosting the workshop for 2 consecutive days, hosting different kind of speakers. Remember, the fraternity of law has a lot of aspects. We have people who deal with litigation. We have people who are prosecutors. We will be focusing on different topics. We even have an AI specialist for today. The law society, the role that they play in our institution towards giving you guys support.
As I have been introduced, my name is Mama Shumabua, and of course, I'm one of the members in the counseling unit. Mine is just too short because I heard Munavisi mentioning a whole lot of things that I was supposed to, but I just want to welcome you to today's law professional event. This is our day 1, as he has mentioned. So we are going to have 2 days workshop with different stakeholders or different presenters for the both 2 days. So please be here with us for today and also for tomorrow, when you are going to be learning more about your profession. We are hosting these events particularly for the students and everyone who has not actually went through proper career guidance or proper career planning when they started this journey, so that they can actually know much about this profession and eventually make informed decisions as they go through their journey, and also to unpack the profession of law, so that at the end of the day, you know the dynamics that have to do with this profession and every challenges and successes that are attached to the profession. We have different presenters, as Munabis has said earlier on. We have Miss Linda Boyi, who is going to be talking about the role of College of Law, because all of you, I think, you are attached to the College of Law, and we are going to be having her to tell us more about what they are doing in the College of Law and all the information that they have for our students. And we also have Advocate Newvold, who is going to be talking about litigation, and Advocate Mudangwa, who's also going to be talking about career as a prosecutor. He is from NPA. So we also have Ms. Margaret Kwangwe, who is also going to be talking about becoming an advocate. And we have Dennis Rampomani, who is also going to be talking about IP and AI as a specialist in that profession. And we have someone from the Law Society, Mr. Machini Mutloum, who is also going to be talking about the role of Law Society in South Africa. So with all of these speakers that we are having today, you must expect so much and you must be willing to learn so much from them. You are welcome, and we are very much happy to host you today.
Okay, now the first speaker we're going to have is Miss Linda Boy. Miss Linda Boy is the college coordinator from the College of Law. Now, today she's here to share information on how they best assist you as our students who are based in the Faculty of Law. And today she'll be sharing contact information.
Let me first start by welcoming you to this program and to the College of Law. I hope this program will give you more insight and knowledge as you journey in your career. Without any waste of time, as Mnabis has said, my name is Linda Boyi. I am the College Information Coordinator / Supervisor for the College of Law. I will be taking you through the kind of support the Information Center will be providing to you as a College of Law student. So let's get into the purpose of our existence. So the role of the Information Center is to advise students on the general processes and procedures of the university, advise students on the general rules and policies of the university. We also play a liaison role where we facilitate the resolution of queries between student and the relevant department. In other words, if you have escalated your query to your registration, your exam department, we will do our utmost best to follow up on your behalf. We actually play the middleman between the student and the relevant department. So one might ask, what kind of queries do we deal with in the Information Center? So the queries that we deal with in the Information Center are queries from the student work or the life cycle of a student. From the very first day when a prospective student indicates their interest in one of our product offering until the student comply with the qualification requirements. So in this case, we're talking about the application, queries, registration queries, dispatch, exam and assignment queries, finance, NSFAS, graduation, and the like. So basically, this is what we facilitate. We are the middlemen. So if you send your query to the application office, and if you're not getting any joy, please feel free to contact us, and then we will facilitate up until your query is resolved. And what is also important is that as you journey along in this profession, you will be required at some stage if you intend to be admitted in the legal practice to provide a testimonial letter, a reference letter from the dean. So we are also involved with that process. We will draft the testimonial letter for you as part of the documentation that are needed for you to enter the legal practice. We also draft the employment reference letters. We also draft bursary recommendation letters, and we also draft study leave letters for portfolio modules. Now, one might ask, what is a study leave letter? We all know that if you are registered closer to the time of the exam, UNISA will now send you the timetable. But then with portfolio modules, there is no specific date on the timetable. So if you are working, you are unable to request leave because there's no date for submission of that portfolio. So we assist you with that letter. So it's just a kind gesture to motivate for you to obtain leave from your employer so that you are able to get time to finalize and submit your portfolio. So basically that is what we do with the study leave letter. But however, if you have a timetable and there is a date, please do not request for a study leave letter. Each and every companies, they've got their rules in terms of study leave. So we cannot, intervene or request for you, whereas there is a date on the timetable. But if there's no date, then the lecturer is able to, through my office, to motivate that you get at least time off a day or two for you to submit and to finalize and submit your portfolio. How to contact us? We've got two mailboxes. We've got the law ordinary at unisa.ac.za. We've got the CLAW enquiries at unisa.ac.za. And also the contact details. This information is also available on the College of Law website. I also want to urge our students not to send queries to the deanery. The deanery are primarily here for teaching and learning, and not registration issue, results outstanding, all those things. If you have a complaint, you rather come through to our office than to send this thing to to the deanery. The lecturers, they can only receive content-related queries. They do not deal with registration. They do not deal with finance issues. They do not deal with NSFAS queries. But then theirs is to deal with teaching and learning, and that's all they do. Okay. And then part 2 of my presentation is the online examination. So one of the things that we do in the Information Center is that we support our students through the college life fit streams. So Basically, the primary purpose of the college life fit stream is to support the student during the examination session. If your session starts at 8 until 12:30, we will be there to support you should you need any assistance. So our life fit stream is made up of your lecturers, the module leaders, the ICT department, the examination department, and the student communication, or what we normally call the call center. So this team will be able to handle whether it's a technical issue, whether you are able to navigate the online platform, will be there to assist you, and just to make sure that you are able to write your exam within that stipulated time frame. If it's a 4-hour paper, we just want to make sure that you are able to write and finish on time. So basically, that is why we're having this college live streams for you guys. I just want to urge to all our students, and I cannot overemphasize this point, that you need to read all the instructions and announcement posted by your lecturer regarding the examination or anything for that matter. Our students, it's funny that students want to be lawyers, but they are failing to read instructions. In this profession, it's all about reading. You read until your head becomes gray. Even the gray ones, they still read. Judge Rata has gray hair and still reads. So it's important for you to read instruction at this level, so that you must get used to reading. Reading is your thing. You cannot divorce yourself away from reading. A lot of students are failing to write on time or to follow the instructions about the exam because they fail to read. Student is prepared. Content-wise, the student is prepared to write the exam. Student does not use the Invigilator app. And such student will then have to face the consequences of not using the Invigilator app. So it's important for you to do the right thing so that you don't have a problem in future. Remember, we have a lot of students who are now in the DCs because of not following procedures and processes as advised by the lecturers, and that will dent your career in future. So when I have to now write your testimonial letter, I'll have to mention that you have a DC. I cannot hide it that you have a DC. And simply you have a DC simply because you did not follow the rules. You did not go to my UNISA. You did not attend classes. Out of 5,000 students who are registered for a particular module, only 200 students attend. Where's the other 4.8 students? So I just want to emphasize the importance of attending classes, of listening to recordings, of reading the instructions, because it's heartbreaking to see a student who fails to navigate the online exam platform. The student, when it comes to content, the student is ready, but the student is failing to navigate, and this is time-based. The next thing, the student, it's 2 hours, the student is still looking how can I navigate, how can I start question 1, while other students are already on question 5. So it is important for you to do that. And one other thing with regard to our exam, which I did not include in the slide, is that if you are registered for a multiple choice question, a quiz, we don't scan through the question paper. We are the only college. You are not allowed to scan through the question paper. You answer as you move. If you are answering questions on question 1, you answer question 1, you go to 2, you go to 3. You don't skip questions, because if you skip a question, unfortunately, you will not go back to the question that you skipped. And then it will automatically submit. And then you'll come back and say, but Linda, I did not press submit. I did not do this. But you are skipping questions. You're not allowed to skip questions. With other colleges, you are allowed to skip. But in our college, you answer as you go. And our questions are randomized to avoid, to keep that integrity. Because we've got students who are writing together. And they think that because we're writing together, we can share answers. If it's question 1, we'll share answers. But with our MCQ questions, they are randomized. Your question 1 is somebody else's question 25. So we are just trying to protect the integrity of the university. So a lot of students are not reading the instruction and they're not aware. So a student opens the question paper, goes to question 1, and then skip just to browse and see if maybe this question is similar to another question, just to check if they can maybe compare the questions. And the next thing, the student is unable to go back. So I just want to emphasize the importance of reading, of attending, of getting used to that habit. It will save you. It will save you, and you will go out of the university with a very good a record. And then also during this exam, this is our mailbox. We only use this mailbox CLO exams at UNISA during the examination period. You can also call the call center, or you can also send the email to inquire, but preferably CLO exams, we are there. My teams are there to respond to the queries. I think I'll stop at that. Thank you, Program Director. Over to you.
You said something very profound under exam important information, but it really didn't make sense. You said we get a DP for not attending classes. Did I hear that correct?
DC, no. I'm saying if you get to the habit of reading your instructions, you won't be able to be part of the group that are having a DC on their academic record, because a lot of students are missing a lot of points because they fail to read the instructions. So if you follow the instructions, you avoid having a DC. Like, students are not invigilated. Students, they don't know how to use AI. Students, sharing answers. There's just a lot of things that they do that they're not supposed to do. So if you attend classes, then you'll be able to get that information so that you don't do what other people are doing. A lot of students are now on DC because they failed to read the instructions. Thank you.
Thank you, Ms. Bui. That was clear.
I'm a second year's master student, and I've also done my LLB with UNISA. What you are saying is very true, because I also told the other colleague of mine that when you study law, you must love reading. So what the university also do is that they give you this, it's like a proof before the examination, how you can go in the Invigilator app and all those things, which is very commendable. But one thing that you guys don't come out strongly about is also that our experience that we have with, remember, if you get technical glitches as a student, that can also disorganize you as a student. And we must also bear that in mind, that some students, we are not the same how we handle setbacks. So the university is not like the universities, how can I say, the way we are doing now is not also on the top level online examination when it comes to the university. They are not yet there. Remember, UNISA was a venue-based examination. So they are also new in this field when it comes to online examination. So they also have some deficiencies. And we must also allude to that most of the students also, they are also being disorganized by these shortcomings. But I'm not blaming students because of, as I already alluded, that we don't treat setbacks the same. But also on the side of the university, I must also be honest to say that the university give you time before the examination to go inside and check or do a proof how you must, on the day of the examination, how you must go about it. So there's some of the things that we must just also bear in mind. Thank you very much.
2 questions from your presentation. The communication center or the call center is important for students when they are facing challenges. Is the department aware that some of the agents there do not know what help to offer, and the frustration and the delay student suffers because of that? E.g., you find that the university, instead of suspending your modules for financial reasons, they actually at times cancel one's modules. And you only get to realize that when you write exams. I have got 2 exams that I've written, and the only way I could pass is because I submitted through the Invigilator app. And even there, I had to go from pillar to post to get those sheets to be retrieved and be marked. The second part is it your department's responsibility to assist with the remark applications if you have modules that you apply for remarks? And if so, do you know why it takes 2 months to release results of the remark after the closure of such applications? This one is a current problem. I have got 1 module that I'm left with to finish, and the remark I applied because I failed it, unfortunately. The message I got was it will take 2 months, and now one is stuck between, should I register this module, should I wait for a remark, or I will get an automatic FI concession type of thing. Thank you very much.
So we've got the call center or the contact center, which we call it the SCSC, and we have the information center. So I'm from the information center of the College of Law. I work closely with the deanery, and then we've got another set of people somewhere that are working in a contact center. So I'm not sure which of the 2 are you referring to in terms of people who are not knowledgeable. But in our case, if you cannot assist you, we escalate it and we follow up on your behalf. That's basically what we do. Obviously, we don't have functions to check things, other people's departments, things we can't check, but we have people that we work with in the background that we can escalate and make follow-up on your behalf. That is that one. Number 2, if you are you have applied for a remark, you have to register before the closing date. And then once the remark says you've passed the module, then you have to request for cancellation and the refund. But then we are saying we are guarding in case you don't make it and then the application is closed. The registration is closed. Then you'll have to come back. Let's say you're left with 1 module. The application is registration is closed and you did not register because you're waiting for the outcome of the remark. Then it means you have to come back next year to register. So you register and then you cancel, you request for refund if you pass the module. Thank you.
My question is regards to the employment letters and reference letters. Can you also apply for it or ask for it as an undergrad student, or is it only for students who have graduated or postgrad?
So usually it's part of the request from the legal fraternity to submit a reference letter. So basically a lot of students are requesting it because they need to submit it, same as you need to submit your qualifications, your ID. It becomes part of the packaging of that application. So hence we are doing usually for students who are in their final or students who have completed their qualification in most cases. We've never really come across students who are in their first year. And I'm not sure if they are going to be first year students they are going to be, given opportunities because they just started with their careers, or their studies. So I'm not sure about that. But what we currently do, we only do for final year students and as well as students who have completed their qualification. Thank you.
Our next speaker is Advocate Elizabeth Nieuwhout. Advocate Nieuwhout, she studied at the University of Pretoria, where she obtained her BLC LLB in 1993. She was admitted in March 1994 and joined the Pretoria Bar in December 1994 after successfully completing her pupillage. Now, in 2004, she joined Legal Aid South Africa as a legal practitioner. Then later in 2018, she was appointed as head of the Tembisa local office, and that's the position that she currently still occupies. She specializes in children's law, and then more specifically representing children in children's courts and high courts. She gives training for lead social workers as well as in-house training for Legal Aid South Africa. Students, please help me welcome Advocate Nirut, who will be here talking to us, actually delving into the matter of litigation.
I don't have a presentation. I'm just going to talk to you and share some thoughts on litigation and some maybe heads ups and some hints that the students can maybe just look into before they make a decision. Because as I understand that, sorry guys, I just need to switch off my heater. It's becoming a bit too hot here. You know, I think a lot of the guys, if I understand, some are first year, some are second year, so they're still thinking about, you know, what will I do once I finish my LLB. And I'm afraid that a lot of students that I talk to, even graduates that have LLBs, they have this idea, this fancy idea of litigation. They want to go and work in a court because what they most probably see on TV or what they see in the movies, which is nothing wrong with that. You know, I'm not trying to say, you know, don't take that in or don't let that be your inspiration. Because a lot of people that want to litigate, they want to be in a court, they want to help people, and there's also nothing wrong with that. To have that passion for helping people through court cases, because that's where most of the people are vulnerable. Court processes, court rules, court buildings are hugely complicated for people that don't know. I mean, like the high courts across the country now is all electronic, so there's no more paper. So how do you, if you're a person from the street, where do you start? I mean, you can't even, like in the old days, draft a document, take it to the clerk, and they put a stamp on it. You now need to have access to electronic platforms. So it's difficult. So that dream of helping people through a court system, and a lot of people have this idea, now I want to become a defense lawyer. You know, again, I want to represent that person that has been accused of murder or robbery or shoplifting. And again, nothing wrong with that. But the reality of litigation is unfortunately not as glamorous as it is on the TV. Litigation is, first of all, there's paperwork. So maybe I must just say something about, there's still the differentiation between the two professions, attorneys and advocates. And basically, if I can try to simplify it as much as possible, is to say that attorneys still do a lot of the paperwork. So the writing of the letters, the consultation with the client. So they have the physical files that they run the court case from day one. So they will take the instruction from the client. They will do the initial, let's say it's a motor accident, the letter of demand, maybe the drafting of the summons. But when it goes, so that's so the attorney, yes, they also do court work, but they do a lot of the underlying paperwork that you need to do to get your case into court. And that's also litigation. Litigation, if you're an attorney, is not only going to court, is to make sure that all the correct pleadings, all the correct papers are filed or drafted so that you can get your case into court. But an advocate, on the other hand, is the one that specializes, and I dread to use the word specialized, but let me stick to that word for the want of a better word, that they do court work. So they're not bothered with the writing of the letter or the receiving trust money to write fees from. They don't do the consultations. They are given instruction to prepare for court. So they have the luxury of sitting in their offices and preparing for a court appearance. They don't have to be bothered with letters and things like that. So this is also one of the questions you need to ask yourself. If you want to say, yes, I want to litigate, I want to be that person that helps a person to take a matter to court. If you want to be an attorney that does that, the one thing you need to be able to do is time management. And the lady just before me that spoke talked about reading. Yeah, so that's your first skill. You have to like to read. Even if you're an advocate, remember going to court is preparation. You must know your court papers, but also this case law that you need to read and prepare. So reading, if you don't like reading, you're in trouble. You're going to struggle. And then that idea of time management, because you need to be able to manage your client's case. And you don't have to have one client. I mean, you're not going to be able to pay your bills if you only have one client. So hopefully you're going to be a big, successful attorney with a large practice, but you need to be able to run those cases. To say, you know what, I have so many months to draft the summons. Then I must send it to the sheriff. Then I must do this. Then I must do that. And then I must do this. And then I must file this paper. And then only do I get a court date. So that processes of getting a pre-trial, filing a discovery affidavit, drafting summonses, those are all litigation. And you need to like that, because that's what you're going to do day in and day out, sorry. So that's the paper part of litigation. And then you get to the court part of the litigation. And that is where I always say to the students that come to me and say, no, they want to be a defense lawyer. Then I say, you know what? Great stuff. Please remember that most of our criminal courts are most days without water. The lifts are not working. They sometimes don't have electricity. And the person you are representing committed allegedly a crime. And I'm sure if I have the luxury and if I would go around this virtual room, there would be very few of us that have not been a victim of crime. Even if it's just somebody that grabbed the cell phone from your hand, or heaven forbid, your family was impacted by a murder or a robbery or a hijacking. So I always say to the students, ask yourself this. If you're a defense lawyer, you're going to stand in a criminal court. Your client is going to be accused of stealing a cell phone. Are you going to be able to say to yourself, you know what, I'm going to remove myself because I was the victim of somebody stealing my cell phone? Can I remove myself from that and then stand there as my client's lawyer, representing him or her without fear, without my own prejudice and my own hurt coming into play? If your answer is yes, then I say to you, by all means. But if your answer is no, then you must really think of, is that what you want to do? And litigating in court is also something that you need to be able to think on your feet. I say it always, and you think maybe, what do they know? Remember, if you're standing there, you've prepared. You've read everything. You have your arguments. You know your papers from front to back and back to front. And now the magistrate asks you something out of the blue that you might not have thought about, because maybe the magistrate or the judge is looking at this case a little bit differently. And they ask you. Remember, you can't now go like, no, Your Worship, can we please postpone the matter to tomorrow? I just need to quickly go and read about this. No, your client is paying you money to be there. And remember, in a civil case, let's go back to my little example of a motor accident. You there, the other parties, the lawyers are there, everybody's paying everybody to be there. And there's a cost implication. If you now want to postpone to tomorrow for you to go and read, there's a cost implication, because then the court is going to say, oh, no, Ms. Nieuwoud, no, I will give you your postponement. no problem. But who's going to pay the wasted costs? Because it's now 11 o'clock and we might have been able to finish this case, but you want a postponement. So who's going to pay the costs for this little postponement of yours? So that idea, you need to be able to really think on your feet. Or to say, Worship, give me just one moment and just collect yourself, collect your thoughts and say, oh, okay, I have it. Also, unfortunately, your opponent might be nasty and they get personal in their argument. They will say something, yeah, I don't know how Ms. Nevo does it, but, you know, I do not do it this way. Then it's not for me to jump up and now start defending myself and say, no, you know, I'm not that kind of person. No. You need to deal with it. So you have opponents that's nasty. And then, unfortunately, you have judges and magistrates that, despite the ethical rules of their ethical rules or their rules of conduct, they also get out of bed in the morning in a bad mood. And they see, unfortunately, you're the first person they see that morning. And then you just say something and they just don't like what you say. And then they take your head off. Do you now get very upset and take your bag and run out of court? Or want to lodge 10,000 grievances at whoever statutory body is there? No. Because why are you there? Remember now, if I asked you, why are you doing this? You would say, I am here, I want to help people. I want to help people to go through a court system. So if you take all of this very personally and you grab your bag and you run out of court because the magistrate were nasty with you, who is going to be prejudiced? Not you, your client. Because litigation, and I'm telling you very, very fierce and very fearsome stories, and I hope I'm not putting you off, but I want you to have a reality check on what is litigation. And I said to you, courts are not nice places. In summer, sometimes the air conditioner is not working. So you sit on with your robe. It's like 40 degrees outside. You wear your robe. That's how it works. So think carefully about litigation, because I can warn you, if the bug bites, you do not get rid of that love of litigation. It doesn't matter what the circumstances are. So the one suggestion I always have for you guys is, while you are here, while you can still make those choices, try in your winter holidays, in your summer holidays, in your short break, when you don't have classes and don't write exams, go and find somebody to shadow. You know, there's a Pretoria bar, there's a Johannesburg bar. I mean, there's lots of attorneys in. And just, even if for 1 day or 2 days, just shadow somebody that goes to court every day. So you can feel the environment. We have students here at my office here in Tembisa that shadowed the practitioners that go to the criminal courts, and they took them down into the cells beneath the court rooms where they had to go and quickly go and get an instruction. And then that specific day, there was no water. So you can imagine the toilets in those cells, the atmosphere in those cells were not nice. But that is the reality. And that is what you will have to do if you want to protect your clients. But go and expose yourself to that, to see if that is what you want. Or go and sit with that attorney that has a litigation practice and let you feel it on your skin. How does it ease to work with that pile of, here's your 20 files for today. Congratulations. This is what you must do today. See how they do it. How do they manage to work through those 20 files and make the cases run, make the cases go to court as they should. Okay, so yes, if you want to litigate, by all means, but just make sure that that is really, really what you want, and that you don't have this very nice, clean picture in your mind of what litigation is. But yeah, no, don't have, if you want to do it, but just do it with open eyes.
Okay, but on a lighter note of the court, I was always pondering with this idea of between an attorney and an advocate. You've just put it for me very nicely in, I've got a very nice idea of what everyone is expecting from an attorney and what is expected from an advocate, which is a specialist in litigation. But the only problem that I'm having on my research, you will advise me if I'm wrong, is that advocates, they merely are depending on work from attorneys, which means they are at the mercy of attorneys. So that was a bit of concern for me, because I also wanted to go that route of being an advocate. But the only challenge that I'm having, or the only fear that I'm having, is that the advocates get instruction from the. So
okay. So yeah, let me answer that quickly. So now, in terms of the new Legal Practice Act, and I see on the program there is somebody coming to talk to you about the two sort of streams. So I don't want to take over from their presentation. But under the new act, there's referral advocates, which is the traditional advocacy practice. But nowadays, there's also advocates that can practice with a trust account. So you can take on instructions directly from the street. So you're not, as you put it, at the mercy of referral attorneys. But I'm sure the person that comes to talk later will elaborate on that. But what you say is true. Traditionally, advocates were only referral advocates. Yes.
No, thank you very much, Advocate. I will wait for that presentation. Okay. But thank you very much for your assessment.
Okay.
But now I'm just laughing here to say, you are saying to us as litigators, if you want to be professional litigators, we need to refrain from sort of being personal. And it's something that, I've just learned now, and I really appreciate for that. But my question to you, Advocate, I'm not sure if from your side, can you maybe give us sort of like a short, brief SOP, a standard operation procedure in terms of litigation, where to start and where it ends? Yeah, I think that's my question to you. Thanks, Advocate.
Yeah, that's a very wide question. So I think if I can say what I've said before, where you need to start is to expose yourself to the courts and the litigation. Because yes, part of the litigation takes place in your office. If you're an attorney, even if you're an advocate, that preparation takes place in your office. But a big part of the litigation takes place in a court building and in a court. So if you start anywhere, before you make your mind up finally, is expose yourself to the courts. It doesn't have to be a high court, or it can be your court nearest to where you are staying. Just go there. And remember also, a court is a public place. You can just walk into the court, except for certain court proceedings that are in camera. Court proceedings are also open. So you can go into a court, go and sit there, just see, what's happening. It would be easier and more worth a bit more if you can know what the case is about. So that's why I say maybe go and find that attorney or an advocate that's willing for you to shadow them. I know there's limited space available for job shadowing, but keep on trying. So just expose yourself. I think in terms of a standing operating procedure, that's step one. Expose yourself to that environment. And then if you can get hands-on, if you can get somebody that's willing to let you maybe draft something so that you have that idea. I'm talking about drafting a paper. Hi, Elizabeth, what on earth are you talking about? What does it mean? So again, just expose yourself to as most of the components of litigation as you can so that you understand what that means.
I've got a question on the assessment, by the way. Thank you very much for the assessment you just gave us. Is there any possible companies whereby we can maybe volunteer to gain practical experience, as you just said, for us maybe to get to know the litigation proceedings or life of an attorney or advocate?
Some of the larger firms have formal volunteer programs. So you actually apply, and they more have like an intern program, which is, I see one of the questions here is your first year. So there's no formal requirements for volunteering or job shadowing. it depends on the person you approach. And I must say, I've never heard of an attorney or an advocate that turned away a first-year student or a second-year student for job shadowing. I mean, we have had school children that comes in and says, you know, I want to do this. Can we come and just work there? So it's, you know, that the firms is Google is your friend. You know, here really Google is your friend. To take the area where you want to go, Google firms, and unfortunately it's going to be literally calling them, going there maybe. I mean, here in Tembisa, we regularly have people that just walk in and say, I'm a 4th year student, I'm a 3rd year student, I want a job shadow. So it's really, it's hard work, but it's just your own planning in terms of just calling. And as I say, some of the bigger firms in your bigger cities like Johannesburg, your big 5 firms here in Sandton, Bowmans, Weber Wenzel, ENS, and I can never remember all of their names, Werksmans, they have formal intern programs, but that you have to apply for. So the others is a bit more informal. But there's no, as I see some of them asking, there's no sub minimum for job shadowing.
Coming through now, we have an advocate, Mutangwa. Advocate Mutangwa is employed by the National Prosecuting Authority, known as the NPA. He's employed as a prosecutor since May 2003. He holds the position of Senior Public Prosecutor under National Prosecutions Service Unit, Skills Development and Training Component, National Office in Silverton. His responsibilities include, amongst others, coordination of trainings and related duties, assist with the implementation of training initiatives, tutors, train and manage aspirant prosecutors. Guys, please help me in welcoming Advocate Mutangwa from the NPA, who'll be delving into the topic of a career as a prosecutor.
Career as a prosecutor, I should indicate that it's a demanding work. For one to be prosecutor, you must have an LLB degree. And currently, the process, or rather, let me go through this. NPA is under the leadership of Advocate Batoy, and I'm in the unit of National Prosecution Service, which is responsible for all the prosecutors in the country, because as NPA, there are different units. We've got the administration, we've got the technical departments, etc. But the National Prosecution Service is currently under the acting Deputy National Director of Public Prosecutions, who is Advocate Mzinyati. He is the head of all prosecutors across the country. He's the acting head. Yeah, and as NPA, we don't work alone. We work with other justice clusters, sister departments, SAPS, and judiciary as well as Department of Justice. And for one to be prosecutor, as of now, to be direct, you must have gone through a program called Aspirant Prosecutor Program. Aspirant Prosecutor Program is a 12-month program wherein people would have applied to become an aspirant prosecutor, those who qualify having LLB, as I indicated before. This is a 12 months. Once you apply, you get involved into a training or in a training wherein you will be trained for 12 months. This training involves practicals wherein you will be in court, directly in court dealing with real cases. But there are also trainings which happen in classes wherein there are facilitators who will be showing you all that have to be done for you in order to become, or for you to go to the for practicals in court. So this is the process of recruitment. There will be an advert which will be advertised on NPA website as well as on DPSA. The advert will be explaining all the requirements for you as to how you should apply. And in our institution, we have got clusters. The clusters, to make it simple, I should indicate that overall in the country, we have got 34 clusters. Clusters are comprised of districts. For instance, we've got Pretoria cluster, we've got Valrand cluster, we've got Johannesburg cluster. So in one province, you may find that there are more than one cluster. We've got Velcom cluster, we've got Umtata cluster. That is how things are. So our advert will clearly indicate as to what is the position, where are the positions wherein people can apply for. Applications will be screened thereafter within the clusters to determine the compliant applications. Candidates who are successful through that screening process will go out and write an exam, which is 3 hours paper. Like for now, I must indicate that there is an advert which came out last Friday, and it is closing up on the 4th of August. So the successful candidates will go and write an exam. After writing an exam, the process goes further, wherein the successful candidates will go for an interview. That is in-person interview. We've got the exam wherein people are writing. Successful candidates will move on or will be invited to an interview at the areas wherein they wrote those exams. So who may apply? So anyone with an LLB, preferably youth, are preferred as of now. But anyone with LLB obtained from recognized South Africa is encouraged. And final year LLB students are permitted to apply. However, they should have completed their degree before the commencement of the aspirant program. Like for instance, I indicated that as of now, there's an advert which is out, which is closing on the 4th of August. And next year's program will start on the 1st of March. Therefore, if a final year student is writing exams now, it means that by the 1st of March 2026, this student must have finalized the LLB degree. Because if not, then the person will be disqualified. So that is the position, and the applicants must not have gone other trainings like PVT. It must be their first time to be in the aspirant prosecutor program, because it is not allowed for one to have gone through the training but could not qualify to get a position and then again to apply to be a part of this aspirant prosecutor program. So that is the position. South African citizens or foreign qualifications must verify their qualifications with SAQA. Applicants who are employed in any government department must obtain approval from their employer before joining the program. This happens because of the following. If you are in a government department and you apply to be in the program, you'll be able to sign a contract for aspirant prosecutor program. And in terms of this contract, you will be earning a stipend which is provided for in this aspirant program, which means that if you are coming from a higher salary and you want to be in this program, you are accepting that I'm moving away from the salary of my department, I'm coming into this program, unless if your current employer says that, okay, he can be in the program, but we'll be paying him on our side. That will be fine. The issue is that he cannot be paid twice by his current employer and also in the program. So that is the process of the application. How to apply, we've gone through all the processes, but the issue is that when you apply through the relevant email which is provided for in the advert. And there's no way wherein you can submit your application personally. It's not allowed to provide it or to send it in hand or in other forms, except for the email which has been provided for. All applications are submitted electronically via the email address of the training center selected by the applicant. And as such, once you have submitted, then you'll get a response, automatic response, indicating that your application has been received. So there's a selection process that happens until you write, and then all the processes that happens. I see their hands. I don't know, program director. They are always coming up. I don't know.
I apologize for that, advocate. Yes, the hands we will only entertain after you finish your presentation. You can continue.
Thank you. The training program, like I've indicated, that the training program currently, we are running a pilot program wherein we've got 14 modules in the program. Modules are written throughout because, like for now, each and every module will have got 2 assessments. That is the formative assessments as well as summative assessment. So the difference is that formative assessments, people or the aspirants do it as a group, and the summative assessment, they do it on their own. And these assessments are assessed by the assessors as well as moderated by the national office. So for one to move from module 1 to module 2, you must have been declared competent in module 1 up until module 14. And as of now, module 14 is practical works wherein a person goes to court, conduct formal bail application, deal with a trial, plea of guilty, and one for plea of not guilty, etc., as well as bail application, which is being defended and which is being opposed by the state. So that is what happens. And before or through the program, there are mock trials which are done in order to give opportunity and build confidence and practice for the aspirant prosecutors before they can get in court, so that they can be able to understand the situation or the process which they are going to go through. Practical courtroom, like I indicated, is module 14, wherein the aspirants will be going to court and deal with cases. However, when they deal with these cases whilst in court, they do it in the presence of a permanent prosecutor for that particular court. So that is the process which happens. The competencies, legal knowledge, communicate effectively, interpersonal skills, demonstrate the core values of the NPA, administration abilities, litigation skills. Those are the core issues that are required. Assessment and appointment, those are the processes which have indicated that we have got formative and summative assessment. Now, the structure of career development opportunities within the NPA. I was talking about the aspirant prosecutor. Aspirant prosecutor is the first step for entry as a prosecutor. From being aspirant prosecutor, you become, the next level is that after 12 months, if you are successful in the program, you are absorbed as a district court prosecutor. District court prosecutor, this is in the magistrate offices wherein prosecutors deal with offenses which are meant for the magistrates, like assault with intent to do grievous bodily harm, common robberies, malicious damage to properties, etc., etc. From district court prosecutor, you can apply and become either a regional court prosecutor or a district court control prosecutor. There are two options here. You, from district court prosecutor, after a period of 4 years, you qualify to can apply and become a regional court prosecutor or a district court control prosecutor. Control prosecutor and the district court manages district court prosecutors. After being appointed as a regional court prosecutor, the next level that you can do or which you can apply for, you can qualify to become a control prosecutor in the regional court. Control prosecutor in the regional court, or the other option is to apply and become a state advocate. State advocates work in high courts and they deal with more serious cases. Just like in the regional court, you'll be dealing with cases like murder, aggravated robbery, hijacking, rape, etc. And these cases which are dealt with in the regional court are also dealt with by the state advocates in the high court. From being a regional court control prosecutor or state advocate, you can qualify to become a senior public prosecutor or a senior state advocate. Senior public prosecutor or a senior state advocate. If you are a senior state advocate, you are more based in court. And if you are a senior public prosecutor, you are more in the management of the court. But senior advocates, you are more in the court, even though you are in the same level. And from these two positions, you can either apply to become a chief public prosecutor or a deputy director of public prosecution. And thereafter, you can also apply to become a regional head for specialized units. Specialized units, we have got like tax unit, which deals with tax cases. We've got SDCU, that is specialized commercial crime units, etc., etc. And from deputy director, you can apply to become a director of public prosecutions. Like for now, we've got 10 DPPs. We've got one in each province. That is, in Limpopo, we've got one director of public prosecution, except in Gauteng. Gauteng, we've got 2 directors of public prosecution. One is in North Gauteng, the other one is in South Gauteng. North Gauteng is in Pretoria, South Gauteng is in Johannesburg. So from there, you can then become a deputy national director of public prosecution. We've got 4 deputy National Director of Public Prosecutions. Like I indicated earlier, that National Prosecution Service is under Acting Deputy National Director of Public Prosecution, Advocate Mzinyati. From there, we've got our National Director of Public Prosecutions, who is Advocate Shamila Patoi. That is our number one prosecutor. So these are specialized specialized units within the NPS. That is SOCA, Sexual Offense and Community Affairs Unit, dealing with sexual offenses, mostly domestic violence, etc. We've got Organized Crime Component. It deals with the offenses which are organized, like racketeering and money laundering, drug dealing, etc. SCCU, Serious Complex Commercial Crime Unit. These are complex commercial crime cases. We also have Priority Crimes Litigation Unit. These are matters which are in the high level, which include terrorism, counterterrorism. Financial institutions are also involved. So cases coming from the Truth and Reconciliation Commissions. This is the unit which is specialized tax unit, tax and related. Truth and Reconciliation Commission component. So that's it. And our office or our component is headed by Advocate Rangaka. If you have got any issues, this is where you can send your inquiries, etc.
My question to you, sir, is the prosecutors, are they admitted attorneys or advocates through the NPA processes, or they need to go the normal route? Thank you very much. For them to be admitted as such.
For a prosecutor to be admitted as an attorney, the prosecutor should have gone the route which is prescribed by RPC. And for a prosecutor to be admitted as an advocate, you have to go through the same route which advocates are being admitted. Like for now, for instance, you'll find that most advocates who are in the NPA, they were admitted before they were even appointed as prosecutors, whereas others managed to get admissions whilst they are within the system. But you have to go through RPC. Thank you.
We will now go to Margaret Kwaye, who's an admitted attorney and the director of the Free State Provincial Office of the Legal Practice Council. I heard Advocate Mutangwa talking about the LPC, responding to Takato's question. So now we have someone who will actually tell us what the LPC does and what kind of role do they play in helping you becoming the professions that you are planning on becoming.
Once again, I am Margaret Kwaje. I am from the Legal Practice Council. The Legal Practice Council is a statutory body that came into effect in 2018. Basically, we are the regulator of the legal profession for both the attorneys and the advocates. In the past, we were known as the Law Society, but in the past, the Law Society was only responsible for attorneys. With the enactment of the Legal Practice Act, we have moved away from separating the attorneys and the advocates, and we now call them legal practitioners who are regulated by the Legal Practice Council. We have 9 offices located in each province, which makes it easy for our legal practitioners to have access to the offices of the Legal Practice Council. To date, we have 40,000 legal practitioners registered with the Legal Practice Council. By registered, I mean they have been admitted as legal practitioners, are enrolled with the Legal Practice Council as either an advocate or an attorney, and that role of legal practitioners can be found on the LPC website. So we always inform members of the public that before you entrust your hard-earned money to someone that calls themselves an attorney, visit our Legal Practice Council website. You can simply type in Legal Practice Council on Google, and it will take you to the Legal Practice Council website. It will also provide you with the names of legal practitioners who are legally qualified and enrolled with the Legal Practice Council to be calling themselves with the names of attorneys or the name of an advocate. The Legal Practice Council, among the works of regulating, what we do is we keep the role of legal practitioners. We administer the registration of contracts, which I will come to later on how to become an advocate. We receive complaints against legal practitioners from the public. We investigate those complaints, and depending on the outcome of our investigation and disciplinary committee, we bring court applications to have your legal practitioner that was found to have committed a misconduct suspended or struck from the role of legal practitioners. Now, today I was requested to come talk to you on how to become an advocate. Before you become an advocate, there are processes that you must follow. And one of them is that you must obtain your LLB degree, and that's in terms of Section 26, subsection 1 of the Legal Practice Act. As you are currently students at UNISA, you are in the right direction. However, you must obtain your degree. UNISA must confer you with this degree. After you've obtained your degree, the journey begins, ladies and gentlemen. You have to do what we call practical vocational training for a period of 12 months. In the past, it was called pupillage for advocates. And this practical vocational training, it means that you will be assigned to a trainee supervisor who is also an advocate, who has been practicing for more than 3 years, who is on the role of legal practitioners and is in good standing with the Legal Practice Council. You will be assigned to this person. You will be doing basically your vocational training for a period of 12 months, whereby you will be trained in court etiquette, you will be trained in trial advocacy, you'll be trained in drafting, everything that you will need to be equipped to become an advocate. Your trainee supervisor will see to it that you obtain it before you get admitted. You will also be requested to complete a structured coursework of 400 notional hours. What does that mean? It means that you will have to undergo a specific training. Besides that training that you will be receiving from your training supervisor, you will have to go specific training with the General Bar Council or any other council accredited by the Legal Practice Council to train you in skills like advanced trial advocacy, to train you on court etiquette. And you must complete this 400 notional hours within the time that you are undergoing your practical vocational training. Now, after you have obtained your LLB, you are registered with your training supervisor. I have to pause here and mention that you don't just register with your training supervisor and hope for the best. You must submit your contract with the Legal Practice Council. If the Legal Practice Council did not register the contract between you and your training supervisor, you, in other words, underwent the 12 months in vain. So it must be registered with the Legal Practice Council. You must have obtained a registration number, and we must have given you the go-ahead. You would wonder, but why must I register with the Legal Practice Council? We need to satisfy ourselves that this person that is going to enter into the profession, is he fit and proper? Now, I heard your former speaker, not a former speaker, but the first speaker saying they will be giving you testimonials. If we receive testimonials from the university that you have cheated in an examination, or if we receive testimonials that while you were staying or your student days, you were involved in some scuffle and you got arrested and you insulted the police and you have a criminal record, we will not register your practical vocational training contract. You have to be a fit and proper person. There must be no former disciplinary hearings against you, either by your employer or by the university, as well as no criminal record that must be in your possession. Then, after you have undergo your practical vocational, or rather, let me say, to correct myself, while you are undergoing practical vocational training, after 6 months, you must do a competency-based examination. The LPC conducts 2 exams in a year for the advocates, one being in April and the second one being in August. The candidates must register for these exams. They sit down and write 5 examinations. We call it the competency-based exam. The exam consists of the motion court proceedings and information and communications technology, trial court proceedings and alternative dispute resolution, criminal procedure, ethics, constitutional law, and customary law. And the last paper, legal writing and drafting, which is an open book. You can bring your books. However, no notes is allowed during this exam. You must pass all 5 exams. The pass mark is 50%. If you get a mark of 40% for paper 1 to paper 4, you are eligible for an oral. An oral will take place at the offices of the Legal Practice Council, where qualified advocates will be asking you the questions. However, for paper 5, which is the legal writing and drafting, there's no oral. If you didn't pass this paper, you will sit for the next examination. So once you have passed all your examinations, you have done all your structured coursework as well as your practical vocational training, which was over a period of 12 months, you will then move to bring an admission to the High Court of South Africa for your admission as an advocate. The candidate that brings the application, which would be yourself in this instance, must serve a copy of this application with the Legal Practice Council. The reason we want to be served with the copy of this application is so that we can satisfy ourselves that you have basically ticked all the boxes in terms of the Legal Practice Act. That's everything that I've informed you of. And also that there are no complaints that we as the council have received against you that renders you of such a nature not to be fit and proper. We would then issue a letter to the Registrar of the High Court informing them that you are fit and proper to be admitted. I just want to emphasize here that inasmuch as the Legal Practice Council will issue the letter of no objection to court to say we have no issue with you being admitted, your prayers, that is you praying to the High Court to be admitted as a legal practitioner and enrolled as an advocate, lies solely in the hands of the High Court. The High Court can decide otherwise from the Legal Practice Council. After your admission application, we then request that you bring your admission certificate that you would receive from the High Court and enroll with the Legal Practice Council. So you will be saying, LPC, yes, my admission certificate, the judges on that day admitted me into this profession. We would enroll you on our roll of legal practitioners. Now, failing to inform the Legal Practice Council of your successful enrollment or failing to enroll with the Legal Practice Council, and in the meantime, you are out in the public practicing as an advocate, it is a misconduct and it is also prosecutable by the NPA because you cannot hold yourself out to be someone that you are not in terms of the Legal Practice Council. Now, I heard a candidate asking earlier on that types of advocates and attorneys. My presentation today was on the types, on how to become an advocate. Unfortunately, I was not mandated with an attorney, but I will take questions on that later on. We have since the enactment of the Legal Practice Act, we have 2 types of advocate. The old advocates that we used to know is the referral advocate, who must be briefed by an attorney. When I say briefed, I mean when you go appear in court, you cannot do so on your own. You must have instruction from an attorney that asks you to represent a client in court. When you go to court as well, your attorney must be present. Now, you also get the trust account advocate, which was brought in terms of the Legal Practice Act. In this regard, it means you would have written a different exam from the 5 examinations that I previously alluded to. It means you would have had an additional exam been called bookkeeping, so that you know how to handle a trust account. Because trust accounts are funds of the public. They don't belong to yourself as an advocate up until you have completed the work that you have been assigned to do. Trust account advocates can have direct access to members of the public, to clients, but this is also to limited matters, because as we know, trust account advocates are not allowed to be doing conveyancing. That's solely for an attorney who's admitted as a conveyancer. They're also not allowed to be doing estates. Thank you, ladies and gentlemen. That is all from my side on how to become an advocate.
So my question is, usually they say that you have to go through law school after uni. Is that the 400 coursework, national hours, or something else?
Yeah, the law school phrase is normally used for attorneys, but it is also compromising of 400 notional hours. In terms of the advocates, you undergo pupillage training. But yeah, it is similar to that of law school. So I've covered it. Remember, I said you have to have your LLB, you have to do your practical vocational training, and the 400 notional hours, which is what everyone now currently knows at law school. You are correct.
2 quick questions. The first one is, I heard about the if you get disciplinary from your company or your institution, then there might be a problem. So my question is that at UNISA, I know my fellow students would agree, a lot of students get disciplinary pendings, either for plagiarism or simply because they cannot use the proctoring tools correctly. So how do we go about that one? I'm not talking about plagiarism because that one we know is wrong, but the problem with the proctoring tools, sometimes it's a huge problem for some learners because they don't know how to utilize it properly, so they get a disciplinary pending on that. So how do we go about that one? My second question is that I know it's out of context, but if you are doing you're not doing LLB, but you are doing a diploma in law, are there other opportunities within the NPA? Thank you.
Thank you, Chair. The first question, Tabeling, concerning the disciplinary history that you might have as a student or from your former employee. One thing is we consider each fact and each matter on their own merits. You said about the tools that you cannot use of UNISA. We will consider what was the type of misconduct you were charged with. We will want a full disclosure from yourself. We will even go to the extent to request records from UNISA. As a matter of fact, we can even contact UNISA ourselves and ask about the outcome and so forth. So if you, like you are saying, making use of tools, I'm just not sure what you mean by tools, but we consider each and every fact.
Okay, but Tabeleng, basically, I think what she's trying to say is that it'll depend on the kind of conduct that you are flagged for. You understand? So obviously, the proctoring tools belong to us as a school. Now, if you're having a challenge using them, we can't fault you for that. I hope I make sense.
Yes, thank you.
Yeah, so obviously, like she said, at least they are very proactive as the LPC. I mean, going to such extents as contacting UNISA for the outcomes of hearings and etc. I don't think most companies would do that because chances are they just throw your CV away if they see a red flag. But I believe they are quite fair because they give you a platform for you to mitigate for yourself. You understand? So that is truly appreciated.
I was still on Tabeling's matter of the disciplinary to state that I was not sure or what kind of tools she's referring to, but we would consider each and every matter based on its merit. And we will go as far as in asking you to disclose the outcome of your disciplinary matter with UNISA. And if need be, we will also contact UNISA ourselves. Like she said, plagiarism, unfortunately, plagiarism is unacceptable. If you also look at case law, recent case laws, we have attorneys that don't do their own work, that uses artificial intelligence to cite case law, and unfortunately the artificial intelligence failed them and created lots of work for the judges to locate case laws that they are not aware of. So things like plagiarism and serious misconducts like dishonesty, that will not be allowed, because we cannot allow someone that is not fit and proper into this profession. The second question on diploma in law in the NPA, unfortunately, I'm not able to answer that question, as I am not working for the organization of the NPA.
My question is actually twofold. I heard Ms. Kwache say you will be assigned to a practicing advocate. I wanted to find out, assigned by who? Do you approach the advocate and then after your application to be placed for PVT, then they assign you? And then secondly, the 400 hours notional hours, can they be done simultaneously for PVT, or do you need to finish the PVT first, then do the notional hours, or vice versa? Thank you.
When I said you need to be assigned to a principal or a supervisor, you would apply. Normally the bar councils, that's where the advocates are. In South Africa, we have the GCB, the General Bar Council, and we have PABASA and other various bar councils as well, but those are the two predominant known bar councils in South Africa. You would apply to them. They normally have the criteria in terms of which students do they want to be doing pupillage, and then the bar council will then assign you to a specific training supervisor for the time. The 400 notional hours, preferable. You must do it while you are busy conducting your PVT. However, if you are not able to, you can do it the next year, or while you are still looking to do your contract of PVT with a supervisor, because we know it's not easy to obtain contracts. You can register to do your 400 notional hours with any accredited body with the LPC. Thank you.
We are going to welcome Advocate Dennis Rampomane, who will be tackling the topic of IP and IE specialist. Now, I just heard Ms. Kwache talking about lawyers who are using artificial intelligence for their work. So I think what Advocate Rampomane will be talking about is relevant to today's topic. Advocate Rampomane, whenever you are ready, the stage is yours. Thank you.
Well, the scope or the brief that I got was I was supposed to talk about the journey of how to become an IP specialist and prospects and so forth. However, I think AI is actually oppressing, and I have a lot of students. I can bet on my left eye that a lot of students want to ask me questions on artificial intelligence. I started specializing in AI from 2022. I'm a techie at heart. So I wanted conversions of science and law and which other field other than intellectual property. So yeah, IP has been my passion since varsity. I did a module in IP. I've been specializing in IP. I worked for government first, and I did my started my master's with UNISA in 2020. And yeah, did my IP, doing my coursework in intellectual property law. Unfortunately, I didn't have an engineering background because the law says to qualify as a patent agent, especially in South Africa, or patented. I don't know whether you guys heard the patent attorney part, but yeah, you need an engineering background. So the law says you need an engineering background, or diploma, or a recognizable science background. And now, as far as I know, there aren't any advocates who are patent agents. Hopefully the law changes and some of us fight that, but that's a story for another day. So I specialize in yes. So in essence, I cannot register patents in South Africa, but I do advise clients on patent work. So I do copyright, trademarks, patents, recently marijuana law, plant breeders' rights, your design law, of course, trade secrets. And largely what I do now is I do a lot of work in AI. I was convinced by my supervisor, advocate in Zaluba, to start writing papers. So I write papers on artificial intelligence, specifically on natural language processing. Well, NLP is basically computers trying to interpret languages, computer programs or AI trying to interpret languages. So I write a lot of work on NLP. The reason I'm doing this is because African languages are deemed low resource languages. So I'm trying to empower, promote, revitalize, and preserve our languages, and also preserve our culture and heritage. So yeah, that is a long and short of it. Yeah, I think yeah, I like interacting with people. So the more questions I get, the better, and then I can tackle issues of AI generated fake cases, which is quite rife. And it's not only attorneys and advocates who are using artificial intelligence or generative AI for such cases. There are also magistrates that are using AI, and I stand to be corrected, I think, a few judges. So yeah, I'm open up for questions.
My question is on AI, of course. I understand that AI is taking over the world, and when do you think perhaps we should be concerned with AI taking the legal practitioners' work and rendering the LPs redundant in the near future, or that future, is it still far? We can still encourage our people to become LPs. Thank you very much.
Thank you for your question. Yeah, I don't want to answer you subjectively. In all honesty, before I started with this journey, I really thought that artificial intelligence was going to take over jobs. The theme at the International Bar Association, I think, or the American Bar, the theme in 2023 was artificial intelligence isn't going to replace lawyers. It's going to replace lawyers who don't utilize it. So, in all honesty, the more you try to learn these controls, these systems, the better for you. It helps propel you, and also puts you at the forefront. Like now, I was at the AFBAR, the African Bar Association symposium with UNIS in 2023, and I was a huge proponent, and I was echoing a lot on artificial intelligence. People didn't take heed. 2 years later, meet at the Spring Law Conference, and people reminded me what I told them in 2023. So yes, if you don't use it to your advantage, you'll be lost behind. You'll be on the back foot.
My question, I like what you said about AI. I'm self-employed, currently working in the insurance industry and coming from a totally different area of practice as a dental technologist as well. So I've been all over the place. But my question pertains to how do you use law within business? I recently was exposed to estate planning and estates because my dad passed away and I was the executor of the estate. And I also registered a trademark. And so I've got a little bit of experience within, let's call it trademark law, as well as estate, as well as running my own business, and then now the FSCA with insurances and so on, and insurance policies and wordings. And that's why I enrolled with UNISA. Currently, I'm first year BCommerce of Law, and going into my second semester, and I realized that my hands are a little bit full. Did I do the right thing to start studying law so late in my life? But because I see the relevance and the applicability within my industries of expertise, what would your advice be to me going forward? Or is this where you pay a lawyer to give you the advice and you carry on running your business? Because that's the kind of thing I kind of enjoyed, having the exposure of being involved with the law regarding the estate, the law regarding the patent, and research and development. All of those things, have a single point that it runs around, which is law and how you manage it, or how you apply law to each and every division that I just described. And I've been battling to find time to do all the work as well as studying. And I just wanted a legal representative or legal professional to give me their insight. And what I liked about what you just spoke about AI is, how do you apply technology? In other words, how do I apply in reverse law or the concept of law to my businesses? And do I need to go and study law in order to do that? Or is it maybe just the way life pushed me into getting involved in law because of everything else that I've done? Maybe it's a bit of a wide question, but if you can share with me your let's call it views on it, I'd really be appreciative.
Yeah, I know quite a wide one. Firstly, condolences on the loss of your father.
Thank you.
Yeah, you seem like you've got your finger in a lot of industries. I see this insurance and your technologies. Look, you're technologists at heart. I think as a science guy or the science background, you have to learn. There's a lot that you learn. You learn every single day. And so with me with AI, if I miss a day's work, it's equivalent to a week. If I'm off for a week, it's equivalent of missing information, a month's worth of information. So try and incorporate all of those in your businesses. With the IP and trademark stuff, I think experience is key, like you said, because you already started. But if you're trying to go the law route, you should have started with your LLB, not BCom law, not not any other variant of law, but start with LLB. But it'll assist because with the business aspect of things. I think we can have a side convo. I don't know, we can have a side, but I'll share my details because I specialize in intellectual property. But kudos to you.
Thank you very much. That I'd really appreciate that. Thank you.
My question, basically, I currently have a journalism qualification, and then now I'm studying obviously towards my LLB, and I currently work for a media agency that uses AI a lot. And I saw the gap, right, in the company that I currently work for, and I think in the industry as a whole. Will AI become an issue in terms of media law? And I don't know how to put it, but in terms of the IP of the writer who, for example, writes an article using AI, and how can I better position myself to be in a space where I'm valuable within the company or within the industry as someone who is both a journalist and a lawyer? I don't know if that makes sense.
No, 100%. I'm glad there's a journalist in the group. Firstly, mis and disinformation. I think you're a journalist. Out of mis and disinformation, because I'm a faculty member of the South African Internet Governance Forum, and I think when people want to dissect this AI conundrum, they think it's only tech-based. No. We sit. What I normally do is I'll sit with data scientists, because I did a short course with the German Industrial Corporation. I can sit with the data scientists, have a conversation. A software engineer, I have to sit with a journalist. I have to sit with the guy from the transfer department for I'll get the name now, slip my mind. So we sit with all these players, and we have conversations. With media and journalists, we'll talk about mis and disinformation. Like I say, the AI background, we'll talk about compliance, but because I've got the practicalities, I did it pragmatically. Then we talk about coding and hallucinations and emergent properties and misalignment, that sort of thing. So I think you place yourself in the right position. You should look at cases like the New York Times versus Mid-Journey, because there's a lot of these cases now. I'm struggling. I'm going to tell you something. I've been struggling. Last week, the week of the 7th to the 11th, I had the privilege to be presenting a paper at UCT at the African IP Law Symposium. And my issue was I had to find a synergy between artificial intelligence and intellectual property. And by far, this is the most difficult thing because as I present my papers, as I write papers, I put on my AI hat or AI practitioner and I write papers. I'll talk about NLPs and data augmentation and annotation and so forth, text classification, tokenizations, all sort of things. So I had to try to measure too. So I had to front end my topic, for instance, because it wasn't few short learning and small language models, empowering African languages or low resource languages. So I have to incorporate it too and I have to find the convergence there. But yeah, it's the most difficult thing I have done, what I've submitted. That's a story for another day. Like I said, I think position yourself properly. Look at those cases. Anthropic versus, I think, Disney. It's a recent case, it was in June. And then it becomes an argument between fair dealing and fair use. South Africa, obviously, but fair use. Now I'm done copyright. So South Africa with fair use, fair dealing, sorry. But in the copyright amendment bill, there's a fair use, and in America they use fair use instead of fair dealing. So just look at those aspects. There are obviously exceptions to the rules. The argument is quite an interesting one. And then missing this information is normally you should look at especially the convergence between AI and elections. I think, and
Okay.
missing this information. Yeah.
Oh, okay. And follow-up question, do you think it's worth it for someone in South Africa to pursue a career in media law or copyright law?
I want to tell you one thing. So November 2024, I was in Egypt I was at the OECD AU AI Dialogue 2.4. I'm 2.0, sorry. And I had this conversation with some of my colleagues, and I mentioned what happened at the Airport Conference in 2023. And these are colleagues of ours from the Department of Communications. So they basically trailblazers in AI and policy formation. And then I told them this. I said, "You see how young I am. I'm going to bring all these solutions to your attention, but I'm going to present once or twice. And if you guys don't take heed, these international guys are going to take heed." I was already people were busy calling me professor in AI. So the value, start in South Africa, start where you are. The value internationally, this is a story for another day. There's certain things I can't mention, but I'll write down my contacts. I'll share them in the chat box, and then I'll take it from there.
Oh, okay, thank you.
Here's my question. So with artificial intelligence being a growing market, one can fairly assume that there's going to be a need for legal intervention to somehow mitigate the possible risk, that come with AI, right? I mean, it's a fact that AI still needs to be aligned with the societal values, of the society. And, the growth of AI, it also brings about burning questions, about the legal personality of AI and all those interesting, never before explored areas that arise from the growth of AI. So, I would even assume that governments have to address these legal implications that come with this, the growth in AI. So my question would be, as a law student, which field of law should I really be focusing on that will set me up for taking part in this? I also have a background in PPE, and I think just sort of an interest in policy work, so how can I, what legal field would be appropriate, to delve into that career,
Yeah, no, thanks for the question. Look, I will advise some of the previous colleagues who asked questions. Start with LLB. From LLB, you'll decide whether you want to become an attorney or a counsel, but you know that you've got LLB in the bag, you can practice. So you with the policy background, which makes life even easier because we need people like you. We need these voices in these rooms. You know what? I also added this in my paper. I tell people, look, we're not deployers. We're all deployers. We're not providers of AI. ChatGPT. Now I'm going to talk about bias and hallucinations. ChatGPT. You feed it certain information and the bias rates, I think about 60%, 60+%. This is when we talk about LLMs, large language models. So in essence, generative AI is a combination between NLP and LLMs. So ChatGPT is not going to give you the response or the Afrocentric response that you want. Then you move to Gemini. the bias is a bit low, especially for us Black people. I don't want to be controversial, but let me just put it out there. Then you go to DeepSeek. Recently, DeepSeek this year, and it was in February. DeepSeek's AI bias is lower than all these other guys. We're still on large language models, but it's still the same bias. I think it's about 35%. When you go to small language models, because people claim that we are data scarce in Africa, Claude, is it Claude or Llama? Claude 3. Claude 3 has less bias than all these other models. So my argument is, I try to walk in the footsteps of organizations like Lelapa AI, grassroots organizations such as Masakane, and so forth, and kudos to the work that they do. Recently, there was something called the Buzuzu Mavi Challenge. They've got an Nkuba LM large language model, which is an SLM, a small language model, training African data, giving African outputs, and so forth. This model is smaller, 75% smaller and less accurate. So now you see the narrative changes now. Do we need this large information or this large data? This data in the data centers are not even they're not even established or in Africa. They are in the north, the global north. So these are the conversations we need. We need people like in the room, and we need a side chat, a fireside chat. Above answered you.
As we continue now with our program, we're having our last and final speaker, who is Mr. Machini Mutlong. Machini Mutlong is an attorney and the director at Machini Mutlong Incorporate Attorneys. Mr. Mutlong holds a BProc from the University of Durban and a master's in human rights. Mr. Mutlong has 25 years of experience in public and private practice. In 2001, he was admitted as an attorney of the High Court and earned the right of appearance in the High Court by 2004. He also became an associate legal auditor with Legal Aid South Africa in 2015. He is the vice president of the LSSA and the president of NADEL.
It's quite exciting that we have young jurists and future members of the profession showing keen interest in the profession, and also being provided quite an extensive information into various facets of the profession, so that as they move into the profession, they are doing so from an informed position, and they know exactly which branch of the law they can pursue, and which branch of the profession they can pursue. That is quite encouraging, not to see someone getting into the space unknowingly, only to find that which he has or she has led himself or herself into does not necessarily resonate with what her expectations or his expectations were. Now, I'm coming from the Law Society of South Africa. As per your introduction, program director, my name is Machini. My surname is Mutlong. I'm the vice president of the Law Society of South Africa. I'm also the president of the National Association of Democratic Lawyers. Now, who is the Law Society of South Africa? What is the Law Society of South Africa? What is our mandate? We, as the Law Society of South Africa, serve the attorney's profession, and this should come out quite succinct in this presentation, that there are two branches of legal practitioners, as Mekwache eloquently presented on behalf of the Legal Practice Council. On the one hand, we have legal practitioners who are enrolled to practice as attorneys, and on the other, we have legal practitioners who are enrolled to practice as advocates. Now, the legal profession tentatively is bifurcated into two branches. Now, Law Society of South Africa and historical background is quite pertinent in us to have an understanding of why we have Law Society of South Africa post the advent of the new act regulating the legal profession, which is the Legal Practice Act. Now, prior to the Legal Practice Act coming into effect, the legal profession, particularly on the branch of law of attorneys, was regulated by the law societies. Now we had the law societies having a regulatory function, but unique in their composition was that, and unique in their duties was that they had what we would call a dual duty. Now the dual duty was a dichotomy was drawn between two parts. One, a regulatory function of members of the profession being attorneys by these law societies. We had 4 of these law societies in the past prior to having the Legal Practice Council taking effect. We had the Law Society of Free State, Cape of Good Hope, and the Law Society of Natal, and we had the Northern Provinces. Now, in 1998, the Law Society of South Africa was birthed, and the 4 law societies were part of the Law Society of South Africa. They became members of the Law Society of South Africa. Very important that the Law Society of South Africa, even then, in its exception, in its character, did not have a regulatory function. Now, on the other function of the law societies then was what I would call, it's a member interest, but what I would call then a union function. So a union function, and you'll get to see the character of the current law society taking more of a posture of a union function, a member interest type of function. So this is a function that fell within the ambit of the then law societies. Now, the legislature saw it necessary to then sever ties and create a body that will exclusively look into and be responsible for the regulation of the profession. And that regulation was then removed from the law societies. And with the advent of the Act, the law societies' lives came to an end. They died, only for one body to survive post the Act, the Legal Practice Act, the LPA, which is the Law Society of South Africa. Now, it protects the professional services of attorneys. So for one to be a member of Law Society of South Africa, you should, as a peremptory requirement, you should be following your profession within the branch of attorneys. So before becoming an attorney, you are a candidate legal practitioner who is a candidate attorney. So members of the Law Society of South Africa naturally will come from the pool of candidate attorneys and admitted attorneys. Now, the Law Society of South Africa brings together 3 constituent members. This is quite important as you get to comprehend the space that we practicing in, and the space where we are operating under. That as the Law Society of South Africa, we have constituent members, and our constituencies comprises of 3 of the members of the profession, and these are the bodies independent from each other. One is the Black Lawyers Association, followed by the National Association of Democratic Lawyers, as well as an independent component, which is any member of the profession, any attorney who is neither an affiliate of the Black Lawyers Association, BLA, or National Association of Democratic Lawyers, NADEL. Such member of the profession should not necessarily be excluded from broader participation within the issues and issues that invokes interest in the profession. So the issues of the profession, as attorneys, we should show keen interest in participating in the issues of the profession. And if you do not belong to one of the two that I've mentioned, you are then classified as an independent component of the profession. You would then be part of the independent cohort, and you can then participate meaningfully in the affairs of this of the law societies and in law society of South Africa. So that just to give you a better perspective of how our governance work, we would have the executive level, which is your members of the House of Constituencies. These are members coming from these three constituent members, BLA, NADEL, independents, and each province is then represented in that House of Constituency. And then you would also have the provincial associations. Each province should have a provincial association, which is part of the Law Society of South Africa. Its composition also mirrors the composition of the LSSA at national level. So at provincial level, you'd have 3 constituent members at any given stage: NADEL, BLA, and independents. Now, sitting here, you'd ask a correct rhetoric in terms of why do we have Law Society of South Africa? What is its function? I'm sure many of you would have seen in various platforms and publications the name LEAD. That acronym LEAD stands for Legal Education and Development. Now, the Law Society of South Africa has, as part of its mandate, to provide an affordable, quality vocational training and professional development to legal practitioners, as well as legal candidate legal practitioners, inclusive of the support staff within law firms in the country. So this, we use a vehicle, the LEAD vehicle, to ensure that we execute meticulously this function, the function of continuous legal education to our members. So there are different components of our legal education and development LEAD. All right. One component, and I heard from one of the attendees asking questions around, I think, PVT, legal School of Legal Practice. Now, this function rests solely within the ambit of the Law Society of South Africa, the establishment of School of Legal Practice. You would appreciate that as you conclude your legal qualification and getting into the space, the practical space of practicing law, the two are poles apart. The two, in terms of the theory that you would have acquired, that would have led to you attaining your law degree, as well as now entering the practice space. Those two worlds are far apart, in terms of their own character. You would have to be exposed to the practical side of the law, of practicing law. So we try as far as possible not to throw newly admitted or even newly graduated legal students into the space. We are avoiding to throw them into the deep end of the swimming pool, lest they would drown. So as a buffer and as a bridge into the legal profession, we established the School of Legal Practice. Okay, there is that School of Legal Practice where you enroll and you attend classes late in the evening. The orientation of that School of Legal Practice is more practical than, so there's a differentiation between what you learned from varsity, but obviously it's a continuation, but more on you getting into the practical side of it. All right. So and there's also that compulsory course. If you cannot attend full-time legal school, the School of Legal Practice, then there are there's a component whilst you are doing your articles of clerkship, or whilst you are you have entered into the practical vocational training with a law firm, and you've been assigned a principal who is, among others, expected to impart practical knowledge through supervising you as a candidate legal practitioner. Part of it is that you would be required to attend course, the PVT course, the 5-week PVT course. At some point, it would be divided into 2 parts, 3 weeks at a go and 2 weeks at a go. But this is over and above you having to attend, to do your PVT with your principal. There is also practical practice management training, which is known to be PMT. The PMT, once you are admitted as an attorney and you would want to venture into practice and practicing on your own, either as a director or a sole practitioner or sole proprietor, then you would have to first satisfy the requirement of having attended and passed practical our practice management training. This is done in an effort to ensure that we lay solid ground for attorneys. Mayor Kwache mentioned something very important with regards to, among other functions of an attorney, is the management of trust account. And this you would be taught more extensively and in practical terms through PMT. Once you pass PMT modules, you will be issued with a certificate which would then allow you to venture into a private practice as a director or a sole proprietor. Now, these are the value add services that Legal Law Society of South Africa provides to its members. In my prelude to this presentation, I mentioned that the mandate of Law Society of South Africa is to present a member benefit and to ensure that as members of the Law Society of South Africa, we embark. I was at the value-added services and benefits to our members by the Law Society of South Africa, and this we achieved through seminars that we have. And these are the seminars where we educate the legal fraternity at large. So these seminars are not necessarily only, provided to the members of the Law Society of South Africa, but the legal fraternity at large, with regards to any changes or any amendments that are there, in as far as legislation is concerned. If there's any introduction of any bill, this is communicated widely to the members of the profession. Would appreciate that the important role that lawyers should play in legislation making process, policy making process. That role cannot be overemphasized. As lawyers, we should actively participate in law-making processes. We are lawyers. We should make laws, or rather contribute to the direction of the development of our laws, including the jurisprudence at large. E-Leader, which also offers a wide range of online courses to legal practitioners or in candidate legal practitioners. And as I alluded when I started the presentation, that the benefit extends to also support staff within the law firms. Also have distance education, and this, there's a whole range of topics that we cover, including conveyancing, if you would want to venture into conveyancing practice, notarial practice, deceased estates. Those are the type of presentations that we offer, or courses that we offer. Your insolvency practice, and mediation. Mediation is becoming a big and a topical issue within the legal space. Those are the type of courses that we offer through LEAD, and this type of courses that we offer. They are NFQ aligned skills programs, and they also generate income through accredited training programs. We also support law firms by sourcing funds for candidacy and internship program. You'd appreciate there that there is CETA, for instance, where in the event that law firms are unable to absorb candidate legal practitioners to do their practical vocational training, there is subsidized internship that is provided by CETA. All that the candidate legal practitioners is expected to do is to ensure that he or she undertakes the full 2-year practical vocational training, or if the candidate legal practitioner comes through having attended the practical legal training course, the full-time practical legal training course, it would mean that that candidate legal practitioner will spend a year in the law firm doing practical vocational training, and the services of that candidate legal practitioner will be paid for on his or her behalf by CETA. Now, we have a very important instrument that we use, the derivables. I'm sure many of you would have had a sight of this publication. It's a journal. It's a journal that we run. It's a journal of lawyers. This is a trailblazer journal, a journal of its own kind. We've never had such in the profession for the longest of time. And what we use the journal for, we use this journal to educate legal practitioners, across the broader legal or spectrum of the profession. So you need not necessarily be a member of the Law Society of South Africa, neither should you only be an attorney. So students can access this journal. So advocates, academics, anyone who would have interest in the legal profession may. And you can even use this journal. There are articles that are published, so you can consult the journal to check if you are busy with research. There could be articles of interest or articles which are relevant to what you are busy with. And these are articles which are quite well reasoned and well researched by the members of the profession. They sponsor their inputs through publishing articles in our De Rebus journal. Right. So we seek through this journal, we seek to provide leadership to the profession and to also keep the profession abreast of the developments within our space. What is interesting, colleagues, and over time, we've seen this over time, is the journal provides a platform to up and coming jurists, up and coming legal practitioners, young legal practitioners, candidate legal practitioners who have keen interest in researching and writing articles. If the articles it comes across as quite well reasoned, which comes across as really thought provoking, which provides a perspective that shows, that the article was well researched. This represent an opportunity for candidate legal practitioners at that infancy stages of his or her entrance into the profession to have his or her article published in the Rebus. And this is a free service to candidate legal practitioners, where we also provide a service of putting their CVs on our publication, on our website, so as to ensure that potential employers may access that portal in the event that they would seek an appropriately qualified and suitable candidate to be considered for candidate legal practitioner position. Next slide, my colleague, as I conclude. We have professional affairs and member interest. And this professional affairs is actually the lifeblood of the existence of the Law Society of South Africa, because it is a department that talks directly to our existence as the Law Society of South Africa. It's a department that, among others, ensures that there is that regular engagement with different, stakeholders within the profession, and also the issues, and also ensures that there are interventions on legal and other issues that affects the profession. All right. So the professional affairs department, or it's a department that would ensure that it is a bridge between the Law Society of South Africa and the profession, and ensures that the profession is kept abreast with developments across the board. I must indicate, for instance, that currently there is quite a topical issue in the country, the legal sector code, which would have wanted the Law Society of South Africa to be part of litigation, to be part of ensuring that we do not conform to things that do not work for our profession. History remembers no conformists. We are challenging the status quo. Unfortunately, we couldn't be part of it, but the Black Lawyers Association, the National Association of Democratic Lawyers, and many other progressive associations, including the Ministry of Justice, have joined the case on legal sector code. Legal sector code, please read it. It's quite important. It's going to shape the legal profession. It's going to take it to another level, in the sense that it introduced a very radical component to the BEE, to ensure that the firms of historically marginalized Black firms gets to the level that would ensure that they are sustainable and they are kept in practice for the longest of time. And the level fields are quite are leveled, with everyone in the profession, with our white counterparts and all of that. So the Legal Law Society of South Africa did not enter that space, but as the Law Society of South Africa, and indicating that we have 3 constituencies, 2 of the constituent members are part of that case. The practice support under the Professional Affairs and Member Benefit Department. This unit, among others, provide guidance and assist members to manage their practices and comply with legislation and rules of LPC. As Mekwache said, as the LPC, their role is to ensure compliance. Their role is to regulate the profession. Now, Law Society of South Africa is there to ensure that we play that union function, to ensure that our members toe the line, our members practice, ethically. Our members are not found wanting with regards to, issues that may lead to misconduct against them, which would then lead to disciplinary action being taken against them through the LPC processes. So we provide several guidelines to our members to ensure that they are fully acquainted with all the processes that will ensure that they keep their practices within the limit that is set by the Legal Practice Council. Thank you. Thank you, colleagues. This would bring my presentation to an end. Thank you for the opportunity presented to the Law Society of South Africa to be part of this highly informative session. And I hope that our presentation added value to what has been done today, and it achieved the desired outcomes. And with those few words, let me hand over the reins back to the program director, and I'm at your disposal to engage further if there are any questions from the platform. Thank you.
As we close now, please help me welcome one of my colleagues who is a student mentor from the Joburg RSC, Unobadzi Dlamini, who will be doing the vote of thanks and closing for us.
Special vote of thanks goes to all in attendance, the organizers, you as a program director, especially our esteemed and knowledgeable presenters, and our participative attendees. Siyabonga kakhulu. We appreciate your interactive questions, and we look forward to our continued knowledge sharing sessions.
Colleagues, thank you for full cooperation and participation.